Hello everybody, welcome to iExamB's Legal Bee. This is Amrita, your law faculty at iExam. In this video today I'm going to start with a series of case laws, all the important landmark case laws. I will be covering topic wise for judiciary exam preparation. In this video I'm going to take up Evidence Act and all the cases for Evidence Act will be taken up in this particular video. This series, first of all, I will let you know how it is very beneficial for all the people who are preparing for judiciary, and not only for judiciary but also for other examinations in which case laws are asked topic wise. If you are going to go through these videos, so it will give you a very good insight about the important case laws. And also I have attached a document along with the video in the description. You can check that PDF, download it and go through all the case laws. You can take a print of it and also keep a record of all the important case laws with you. केस लॉज की स्टडी आपकी प्रिपरेशन को काफ़ी थरो भी बना देती है, आपके कंसेप्ट्स को भी क्लियर कर लेती है. इट कीप्स यू वेरी मच अपडेटेड. जुडिशरी में डायरेक्टली केस लॉज से क्वेश्चंस आते हैं एंड कुछ दूसरे भी एग्ज़ाम्स हैं, like if you are preparing for examinations which are like UGC net, which are basing on case laws, research based examinations, state level entrance tests. यहाँ पर case laws से questions पूछे जाते हैं. Subject आपको choose करना होगा. If you are going for evidence, of course that is irrelevant for judiciary, that is not there in the syllabus of UGC net. लेकिन अगर आप constitution का चेक कर रहे हैं वीडियो जो मैं आपको लेकर आऊँगी इस पर्टिकुलर सीरीज में, दैट विल बी रेलिवेंट फॉर अदर एग्जामिनेशंस एज वेल. सो अकॉर्डिंग टू दैट you have to go through all these videos and keep a record with you. Don't forget to subscribe to the YouTube channel, as this is going to be very beneficial for all of you. Stay updated with the series and check out all the videos regularly. और सारे ऑनलाइन कोर्सेज चेकआउट करने के लिए आई वुड सजेस्ट गो एंड विजिट द वेबसाइट ऑफ iExamB. You can also call on this number and check out all the details, talk to the people and get whatever details you want to, and also you can email us at hello@iexamb.com. So let's start. केस लॉस जुडिशरी एग्जामिनेशन पॉइंट ऑफ व्यू से मैंने ये वीडियोस एक्चुअली बनाए हैं, बट so the topics will be as per the judiciary exam, but it is also relevant for other people जो प्रैक्टिस भी कर रहे हैं, तो उन्हें एटलीस्ट एक बेसिक लॉ क्या है ऑन द पॉइंट ये केस लॉज के ज़रिए पता चलेगा. सो इट इज़ नॉट दैट इट इज़ ओनली रेलिवेंट फॉर जुडिशरी प्रिपरेशन, बट इट इज़ रेलिवेंट एज अ होल. Comprehensively you are able to prepare a particular subject through case laws. You are updated with the law that has been set on the point. So do take benefit of all these videos. And if you have any queries, you can also reach out to me at the comment section in this particular video. या फिर आपको कोई सब्जेक्ट पे वीडियोस की ज़रूरत है या कोई केसेस में डाउट्स हैं, आप कभी भी हमें रीच कर सकते हैं. So let us start with Indian Evidence Act first, the important cases. R versus Foster, 1941, a very initial case and a very landmark one. The accused in the instant case was charged with manslaughter for killing a person by driving over him. So his driving, rather the car which he was driving and the speed at which he was driving was witnessed by a person who was standing nearby. He did not actually see the accident, but he has seen some parts of the incidents before and after. So those incidents, if joined, will give a clear-cut indication that this accident has been caused by the accused. He also heard the cries of the victim who was actually dying, and he reached that spot. Victim died after making a statement to that person that what was the cause of the accident. So the statement was held as admissible. Whose statement? The statement of the witness, the passerby or the person who was standing there. He had seen that car that was coming at a high speed. He had also talked to the victim. He had seen his cries. He had and whatever statement the victim had given to him, he had taken it. So this was amounting to a hearsay evidence actually. So the question was whether it is admissible or not. Actually, he did not see the actual incidents that the car was dashing that particular victim. He did not see that, but the chain of causation that is being established here and the series of incidents are connected with each other. So the doctrine of res geste was established in this particular case, and it is a very, very important case law. Doctrine of res geste is a very important topic in Indian Evidence Act. So it was held as admissible, part of same transaction. Pakala Narayan Swami versus Emperor, a very landmark case again from Indian Evidence Act. In this, Lord Atkin had made a statement that the circumstances of the transaction which resulted in death of the declarant will be held admissible if the transaction is having some proximate effect with the statement. So this case is very important not only for dying declaration but also for confession. डाइंग डिक्लेरेशन के लिए केस काफ़ी ज़्यादा इम्पोर्टेंट है बिकॉज जो स्टेटमेंट इसमें दिया गया है it was held that the statement which the accused had made to his wife the last time he met him can also be considered to be a part of dying declaration, or it can be said to be a valid dying declaration under section 32 clause 1 of the Indian Evidence Act. इसके अलावा जो कन्फेशंस दिए जाते हैं उसके बारे में भी इस केस में ऑब्जर्व किया गया है. सो दैट्स व्हाई इट इज़ इम्पॉर्टेंट देयर एज वेल. बट मेनली ये केस डाइंग डिक्लेरेशन के लिए काफ़ी इंपॉर्टेंट है. सो दिस केस टॉक्स अबाउट confession, but it says that the confession should be considered as a whole, and it cannot be treated that only one part of the confession statement can be considered as a confession and the other can be rejected. इस तरीके से आप कन्फेशन को ब्रेक नहीं कर सकते. सो दिस वॉज अनदर इम्पॉर्टेंट थिंग दैट वॉज हेल्ड इन दिस पर्टिकुलर केस, एंड ये एविडेंस एक्ट का सबसे ज़्यादा लैंडमार्क केस है. आई वुड सजेस्ट आप इसे अच्छे से पढ़ के जाएं. नेक्स्ट, तुकाराम वर्सेस स्टेट ऑफ महाराष्ट्र 1979 मथुरा रेप केस, कॉमनली नोन एज. दिस इज ऑल्सो अ वेरी इंपॉर्टेंट केस. पुलिस स्टेशन में रेप हुआ था. अ गर्ल वॉज एक्चुअली alleged to have been raped by two people. In Mathura, this case has taken place. But क्या हुआ था? Sessions judge has held that there was no evidence, so had acquitted the accused. But one thing that was noted by the sessions court was relating to the victim being below 16 years of age, and she was actually she was branded as a shocking liar. And her testimony was riddled with falsehood and improbabilities. This statement was made by the court. And then it went in appeal to High Court. The High Court on appeal convicted the accused, reversed the decision, and there was a passive submission that was involved at the police station by the girl. So it was said that it is amounting to consent. This was said, and this was said in the sessions court, but High Court has actually not consented, has not considered it to be a valid consent. Just a passive submission, that too in a police station, cannot be deemed to be a consent. ये होल्ड किया था हाई कोर्ट. After that the case went to Supreme Court also. The Supreme Court on appeal acquitted the accused. Finally the accused was acquitted and held that the onus is always on prosecution, that the proof should be affirmative. Each and every ingredient of the offense should be proved if you want to give punishment. And section 114A that was inserted in the Evidence Act relating to presumption in favor of victims in rape cases, it absence of consent के लिए एक प्रिजम्पशन ऐड किया गया है बाय एन अमेंडमेंट इन द इंडियन एविडेंस एक्ट इन 1983. बट ये केस कब हुआ था डिसाइड? 1979 का केस है. उस समय ये अमेंडमेंट नहीं था. देयर वाज अ लॉट ऑफ ऑब्जेक्शन to the decision of this particular case, and the consent defense that is being taken by accused time and again, उसको ये अमेंडमेंट काफ़ी हद तक नलिफाई कर देता है. And it is not that the law has to be balanced, and as per the times it has to keep on changing as well. So इस particular decision में actually जो हुआ है, that is very much connected with the amendment that has been made to Evidence Act section 114A, which is an important amendment. You also have to remember the amendments that have been made and the provisions, the number of the section, everything you have to remember for all such landmark cases and the amendments, important amendments. Kalu versus State of UP 1958, another important case. In this case, circumstantial evidence has been talked about. Kalu was charged with murder of deceased by shooting him with a pistol. So the circumstantial evidences were like that. Few days before the killing of deceased, accused has held out a threat against him. There was a threatening few days before. Then the cartridge by which the deceased was killed was found near the court of the deceased. And the firearm expert has also given his opinion. just a small tip I would like to give you. एक्सपर्ट ओपिनियन इंडियन एविडेंस एक्ट का सेक्शन बहुत ही इंपॉर्टेंट टॉपिक है. ऐसे पढ़ते वक्त क्या होता है, जब आप केस लॉज पढ़ते हो, यू ऑल्सो कम अक्रॉस सर्टेन कंसेप्ट विच आर अलाइड और विच आर डिस्कस्ड इन दैट केस. सो उस समय उस सेक्शन को भी रिवाइज कर लिया कीजिए, सो दैट यू आर हैविंग अ वेरी comprehensive study and a good revision of all the sections and the topics along with these cases. So section 45 I would suggest do refer. So in this firearm, expert had given an opinion that the cartridge that was found near the cot of the dead body was given from the same pistol. It was fired from the same pistol that was produced by the accused. So this is what is a chain has been established over here, a chain of circumstances. So circumstantial evidence also holds a lot of value. This is what is held in this particular case and has been discussed in this particular case. In this case, there was no other possibility that anything else can be concluded from this particular situation. So if there is no other conclusion possible, accused can be convicted. Udayabhan versus State of UP 1962. In this case, question was relating to section 27, another interesting and an important provision. Section 27 talks about discovery from the statement of the accused. Accused statement, if it is about self-incrimination, you cannot do that. This is said under Article 20 of the Indian Constitution. लेकिन अगर उस स्टेटमेंट में से आप कुछ कोई फैक्ट को डिस्कवर कर सकते हो, that is permissible, and that has been discussed in this case law. What all things you can consider: the object found, the place from which that has been produced, and the knowledge of the accused about its existence. That also can be taken from this particular case. Gurbachan Singh versus Satpal Singh 1990. This case is also very important and it is dealing with a very important provision, section 113A of the Evidence Act. It is saying that this provision, which is an amended provision, has a retrospective effect. And in this case, what had happened? Ravindra Kumar, who is the daughter of Gurbachan Singh, she was married to Satpal Singh in 1982, and then she died of burns injuries. So her father-in-law and Satpal Singh, her husband, were charged with abetment of suicide. So the question was whether they can be convicted under 306 of IPC, drawing a presumption under 113A of Evidence Act. So the High Court acquitted them because this provision came later, but the Supreme Court affirmed the conviction, and it was also held that retrospective effect can be given to it. So this was also a very important case law, as it is talking about retrospectivity, and the provision is very, very important. It gives presumption in favor of the woman who it is a presumption that cruelty has been made out to her within 7 years of her marriage. If it is being carried out to her, then her death has been abated by the family members or her husband. Moti Singh versus State of UP. It was held in this case that if the person survives, then his statement cannot be said to be the statement as to cause of his death. ये भी एक interesting case law है. Badruddin versus State of Maharashtra 1981. In this instant case, there was a quarrel that was going on. Accused and deceased were quarreling. Accused dragged the deceased from his house to Chowk area and began to beat him. So then what happened? A villager had witnessed this incident. He went to the police patil. There are police patils in villages basically who are doing this particular job. So the statements that are given by police patils are actually based on hearsay evidence. So the question comes that whether these statements can be admissible. So this is an admissible statement. It was held in this particular case. There are some more cases to this discussion, and I would recommend all of you, due to shortage of time and length of the video, I cannot cover everything, but I have covered the very, very important cases though. एंड इसके अलावा और भी कुछ केसेस है. रविंद्रनाथ मूर्ति नायडू वर्सेस स्टेट ऑफ वेस्ट बंगाल थोड़े रीसेंट है कंपैरेटिवली. जेंटला विजय वर्धन राव वर्सेस स्टेट ऑफ आंध्र प्रदेश, स्टेट ऑफ हिमाचल प्रदेश versus Niku 1996. All these cases and more cases are there to it. I would suggest कि आप इस वीडियो को पूरा देखने के बाद आप इस PDF को डाउनलोड कीजिए, जो वीडियो के डिस्क्रिप्शन में आपको मिल जाएगा. आप इन सारे केसेस की समरीज चेकआउट कर सकते हैं, एंड इनके अलावा और भी कुछ केसेस हैं. आई वुड सजेस्ट दैट यू डू डाउनलोड इट एंड चेक इट आउट. And I would again like to give you an important update. Exam has come up with a revision and a practice test series that is for 6 months duration. There will be 2 tests each for prelims and mains per week, weekly tests. And 1 class also you will be getting in this course, that is for questions discussion per week, मेंस क्वेश्चन डिस्कशन. प्रीलिम्स के लिए तो इतना ज़रूरी नहीं, बट मेंस के लिए काफ़ी सारे गाइडेंस एंड टिप्स की ज़रूरत होती है. So 1 class for mains question discussion also you will be getting per week. So it is a very good offer. Currently the batch has been started, so download the test plan also and check out all the details. There is also a very important update, that is about a expert session which exam is going to organize with one of an experienced and a senior lawyer who is practicing at Punjab and Haryana High Court and the Supreme Court of India. It's an excellent opportunity. So you can meet Robin sir. He is practicing for more than 25 years now, and he will be guiding you all and answering all your queries relating to litigation, judiciary, ADA. All these courses are also available at iExam, so do check the details out. And आपकी जो भी queries हैं, ये एक बहुत ही अच्छी opportunity है कि आप इनके साथ interact कर सकते हैं, and it is a free workshop. So do register for it and take the benefit that you are getting as much as you can at iExam. And for this, don't forget to subscribe to our YouTube channel. Stay updated. Thank you, everybody.